Good morning. The SSA just put out a little article online, but most people probably don't see them. I get email alerts from them. And it was just a reminder and I thought it was helpful because some of the things that they put out are really kind of impractical for everyday internet users. But this seemed a little more practical, and I wanted to reiterate it. It's when a widow will be eligible for benefits, because there's a few different times when he or she may, widow or widower. So let's just go over that really quick. A widow or widower may be eligible for benefits if they are age 50. Now, SSA didn't mention this in their article, but you have to also become disabled as that widower or widow within 7 years of the passing of the spouse. So your spouse passes, you become disabled, and you become 50, and all that happens within, well, the disability happens within 7 years of the passing of the spouse. You could be eligible for benefits on the spouse's work record, because you wouldn't necessarily be eligible on your own work record if you didn't have one sufficient at that time. And that could be a variety of reasons. Now, I remember a particular case when this happened. I was actually proving a disability case for someone, and then the issue arose that the spouse was passed. The unfortunate thing, and she would have gotten more benefits under the spouse's work record than her own. Like, she would still get them on her own, but they were much smaller. So she'd get them on her own if she proved her own disability, which we were able to do, but she could get more having proven disability if she could prove that she was married to the alleged spouse, which was the parent of her children. If she could prove that marriage. Ironically, she couldn't. She could never get a document saying it, and her children, even, they didn't know. It was before their time. It was all kind of understood, which, as children, we don't necessarily see our parents' certificate of marriage. So she never could prove that she was married to the gentleman that had passed. I don't really doubt that she was, but for whatever reason, and she had no recollection of even what state it was in. This is how bad off she was. So there was no, you have to go through your state vital statistics and all that stuff. And that is always left up to the person to have their marriage information. So she didn't prove that. And the kids never saw a certificate, anything of that nature. So that didn't pan out for her. But, for everybody else who actually keeps track of that stuff, it's worth noting that as early as 50, you could collect a benefit based on being a widow or widower, whether you have your own work record or not. You could have been a stay-at-home and not have one. At age 60 is the one we normally think of as a widow's benefit start date. I kind of consider it like a widow retirement age. Normally we can collect a spousal or ex-spousal benefit at 62 based on a prior spouse's work record. For widows, and by the way, they could be divorced widows, 60, it starts 2 years earlier. However, like the age 62 early taking of any kind of retirement benefit, this benefit will also be discounted. So if a widow or widower wants to take it at 60, they're going to be taking about I think it's 71.5% of what they would take as a widow if they waited until their full retirement age. So it is substantially decreased. And no, it doesn't pop up if you take it early once you hit retirement. Some people say, well, is it going to go up when I hit it? No, you're taking X years of additional payments. So let's say it's 6 years of additional payments. That's 6 times 12 months. That's 72 payments that the other person who waits till full retirement age isn't taking. So your discounted amount, your reduced amount for taking early is permanent. So that's a risk people can run. Is that going to be enough money later, or was it better to maybe plug a few more years of work in, and not have to take that? If widow's benefit is going to be the thing you rely on, so obviously you're going to weigh those competing amounts. Is my own benefit going to be more than the widow's? Doesn't matter, and I could take it. One thing about widow's benefits too, if you take it, it doesn't impact your own. If you had taken at 62 early spousal benefit, that's deemed as taking your own benefit, and you can't then later try to hop to your own record at the full amount later. That's not true with the survivor widow's benefit, and I hope they don't change that. If you take it early, it does not count. It's not deemed as having taken your own. So you can take the widow's benefit, let your own delay. And so you don't get that penalty if you take your own later. So that's kind of a nice thing. Thank God they didn't take that away from the widows and widowers, because they took a lot away in 2015 from spouses. So they didn't really touch this one, thank goodness. You can also collect a widow's benefit, a survivor benefit, based on your spouse's work record. If you have a child, that person passes, and you have a child under your care who is under age 16, or if they're disabled before the age of 22. So basically, we refer to this as the widow caretaker benefit. That widow benefit will end though when the child turns 16. So keep that in mind. If the child is disabled and deemed that by Social Security, whether it's through an SSI finding or what have you, then as long as that child remains disabled and being cared for by the widow or widower, that caretaker benefit can continue. Going back to the age 60 taking of the benefit, that requires that you're not married. However, you can take it later if you remarry, if your remarriage is after the age of 60. So if you collect a widow's benefit at 60 and remarry at 62, you don't lose your widow's benefit. If you remarried, if you were widowed at 58, had no benefit because you weren't 60 yet and you weren't disabled and you weren't a caretaker, and you remarry at 59, you just lost that. Now, if you get divorced, you might be able to revert back, but so just keep that in mind. Sometimes delaying that marriage till after 60, if what you want is that widow benefit, versus if you have a better one yourself, or you have to again weigh all those different amounts that will be had at different times, eligibility, and which ones would be impacted if you collect now versus later. So you can kind of weigh the options of taking now versus later. So anyway, I hope that helps you. That's basically 4 areas of widow or widower eligibility to keep in mind if, gosh forbid, you lose your spouse. And again, these can apply if you're divorced from that spouse as well. So, so pay attention, and I hope that helps someone who might otherwise have foregone benefits because they didn't know about it. Have a great day.